morning, everyone. Thank you so much for joining us for our free Thursday WA webinar. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate in Queensland, and I'm your host today. Today's webinar, presented by Greg McGuire from Landgate and Jamie Horner from Empire Strata Management and REIWA, focuses on the 5-year statutory review of West Australia's Strata Titles Act 1985. There was significant public engagement during phase 1 of the 5-year statutory review of the Act, which took place in October last year. And it was great to see that over 87% of feedback was submitted by strata owners. And this indicates a strong interest and engagement from those directly impacted by strata living in Western Australia. The review aims to build upon the legislative improvements started in 2020 to make strata clearer and fairer for WA strata owners, residents and industry professionals, focusing on themes such as improving cost controls, enhancing strata living and strata management practice and standards. The substantial feedback, particularly from strata owners, will be crucial in identifying the key issues prior to the second consultation phase in the first half of this year, where proposed strata law reforms hopefully will be shared for public comment. So before we begin, I'd like to mention that the information in this session, including the discussions arising from submitted questions and chat conversations, is not advice and should not be relied upon as advice, and you should seek independent advice before acting on the information contained in the session. Now, we welcome Greg McGuire, Principal Policy Advisor at Landgate. Greg leads the legislation and policy team, and he has over 17 years experience working at all levels of government in a diverse background that ranges from regulating professional boxing to supporting the implementation of e-conveyancing operating requirements in Western Australia. He was the key member of the Strata Titles Act reform team implementing the 2018 amendments to the Act, and he remains heavily involved in Landgate's work in the community title space. Now, he is currently working primarily on the review of the Strata Titles Act on behalf of the Minister for Lands. And then Jamie Horner, Principal at Horner Strata Management and Chair of REIWA Strata Committee, is also joining us. And Jamie opened Empire in 2003. Jamie has been working in the real estate industry for more than 28 years and is a trainer and assessor for REIWA, which provides the only WA-based certificate in strata community management. With a focus on continuous education, Jamie has a degree in business, a master's in property, a Cert 4 in training and assessment, and diploma in business. And Jamie also holds Cert 4 in strata community management. So we're really happy to welcome Greg and Jamie to the session this morning. Thanks so much for joining us.
Morning. Thanks, Nikki.
Good to be here.
Getting straight into it. Obviously, in WA, we do have massive growing pains when it comes to the Strata Titles Act. Obviously, the multi-resident development sector has absolutely grown in the past 8 years. We have an act that was written in 1985, had quite a bit of a review in 96, I believe, Greg, and then 2020 was absolutely needed. The growth in strata since 1996 to 2020 has been amazing. Just some headlines, because I always love a few headlines. They do believe in WA that apartment growth will outpace houses over 2025. There's multiple reasons. Obviously, affordability being the major one. We know that we are in a housing crisis, which definitely means that people are looking, whilst we've always had that dream of having the 800 square metre block or the 1,000 square metre block that went to 800 and then went to 500 and then went to 300, reality is that affordability is now the townhouse, the villa, and for a lot of our downsizers as well, apartment living. The per unit price is absolutely on the rise, which people do also find interestingly enough. But again, that is affordability. We do have more than 4.1 million Australians live in apartment schemes. And I do believe that that statistic is from 2001, 2002 census. So we've probably got quite a bit of more. We have roughly a quarter of WA's population that live in strata. Again, most of those are small lot schemes. In WA, we do have a lot of 5 lot, 6, 7, 8 small type schemes. Lots of development in that multi-residential. More people are living in strata title properties than ever before. And in WA, high density and multi-residential developments are absolutely the future. They're the efficient ways to accommodate our expanding population. So for anyone that doesn't know, WA has net migration, not only from overseas, but also from interstate. So our population growth is roughly about 1,500 to 600 people per week. And we roughly only have about 8,000, 9,000 properties available for sale and 2,800 available for rent. So in WA, the numbers are tough. Demand is high and supply is low. The strata industry is growing. Prior to coming on, Greg actually said to me that a lot of the feedback that they got from the review today was about strata managers. 30% was strata managers, positive and negative. And when I look at most of these headlines that I've pulled over the last year, you'll see that a large portion is strata management. We've had fines. We obviously are all aware of, the ABC Four Corners reports. Strata managers, I think, Greg, for the first time in 2020, it was the first time we were even noted in the Act. Would that be correct, Greg?
Yeah, that's correct. Previously, you were just service contract providers or something like that.
So I think for a lot of people, they don't realise that strata management in itself has only sort of been, as a manager, found in the Act since 2020, which still makes us about 4 years young, I would say. I don't feel young in this industry anymore. But something to understand is that we're also just working through a lot of what's come through by being recognised in the Act. And I'm going to give you the opposite. If you were a real estate agent, you have an Act that comes from 1987. So the requirements of a real estate agent or a property manager have been around for a long time. They include an Act, a code of conduct and regulation. So thank you for us being placed in the Act in 2020, but I still think that a lot of the complaints we have is that we're just trying to work out how that works for us as an industry. If we're going to take away the strata managers' headlines, we still have building issues. So something to remember is that we still have cladding issues. We still have defective buildings, which are a really large portion of strata angst and strata funding. The other items that we're looking also over here, other than strata managers and building, is affordability. When we are looking at strata levies and people being able to live in a property, you'll see that some of these headlines talk about more protection for strata residents. We're talking about the fact that people can't afford to pay their strata levies. It's one of those things that, you pay your rent, you might pay your mortgage, you'll pay your power and your gas because it gets shut off, and then you have to skim on everything else. And this quarterly bill that you get, where the interest is at 11%, people really let that build up when the cost of living is tough. And it does mean that we are seeing a lot of people have to go through the magistrate's court in relation to paying levies. And if we also understand that most of WA strata schemes are small, when one or two owners don't pay their levies, it really cripples the scheme. So there's both sides of things that when we look at it, that yes, it's really hard with cost of living these days, but if a strata scheme is not getting that levy income, it is a problem. The last thing I'm going to highlight, other than strata managers and obviously cladding and building issues, as well as cost of living, is that in a strata building, we have humans. And we always say as property managers that if we looked after the building, it would be fantastic. We'd send in a creditor, we would fix a roof, we would get that sort of stuff done. But when you have people living in close proximity, a lot of the issues are not necessarily the building or the structure. They're all things that can be fixed. It is the people. It's how people relate to each other. I always say that retirement villages or places where people live in small, close living, they're hard to manage. Do you know what I mean? In the sense that they can really have high personal touch issues as opposed to building issues. I mean, if we all think about it, if we all had to be in a car for a day with 10 people, would we all get along, let alone have the same opinions or be able to live and agree on fixing things? So there's two in here, and look, one of them I'm not going to say is more funny, but vegan loses strata dispute over smell of meat from neighbour's barbecue. This was almost 1.5 to 2 years where the case went through. It was appealed over people being able to barbecue. And you can understand, if you're a vegan, you do not want that, but again, we're trying to deal with people here as opposed to property. The other one that's probably a little bit more scary and something that we are seeing in property management is the WA drug addict jail for neighbour murder. This was a person who recently unfortunately murdered his neighbour, was not in a great mind space, obviously already had access to the building because they lived in the building, and people at times can feel extremely unsafe in their building. So it is the biggest thing that we need to factor in, and I think I'm going to show it in the next slide, is that, you know, Greg has this really hard task of trying to put a legislation in that encompasses all of this. You know, in a Residential Tenancy Act, we have an owner/property manager, and the legislation has them interchangeable. They can act on their behalf. We have a tenant, and we obviously have creditors, and we have a magistrate's court. But this is the complexity of strata. If we all just managed a building, we'd be getting on really, really well, but we don't. A lot owner can be the Department of Housing. It can be an owner-occupier. It can be an investor. You know, I still have owners say to me that they believe a tenanted property should pay more in levies, that there is a different reason that an owner-occupier has a different level to tenants. We still have that opinion, unfortunately, in schemes. Landgate is a big component, and you can see them there. I didn't mean to put them at the bottom, Greg, but Landgate is such a big part of what we're doing. But we also spend, you know, obviously SAT Tribunal. Demers also is in there. If we do debt collection, we have to do it via the magistrate's court. You know, I know strata managers that know the WA police on dial. You shouldn't know the WA police number or your local person on dial. We have the Strata Titles Act. We sometimes have to jump into building commission issues. So, you know, I haven't even touched on WHS being in there. So I think a strata manager or anyone that works in strata has so many of those items. Look, funnily, I put a picture of pets on there because we've got the human component, and then we've even got these other human components called pets, which again are another large part. A lot of people also don't understand the difference between a property manager and a strata manager. So I will be honest, you know, even Google doesn't allow us to be considered a strata manager. There is no strata manager listing as a profession. When I am doing any AdWords or anything like that, a lot of people still Google the word property manager, thinking a property manager is a strata manager. We're still a really infant stage in WA, I do believe. And then again, guys, I don't think a lot of people know what the Council of Owners is. People don't even realise how the Council of Owners works and those sort of stuff. So I think that we've got a lot of education and a lot of moving parties. We also have the added issue, and I know that I talked about this with contractors and building issues, but we have an extreme labour shortage in WA. I met with some owners a few weeks ago because they felt that any contractor that works for a strata manager must double their bill. They instantly said to me that, gosh, they must work for strata schemes and just double the bill by the time they pay you your commission. And they didn't realise that how kind and nice we are to our contractors. Like, they literally come in and we're like, do you want a coffee? It's quite the other way around. We are begging our contractors to get to strata schemes. You know, if we have, and Nikki, I'm mindful that you obviously had, you know, obviously a cyclone and lots of things to deal with, but, you know, any normal heavy rains, and it would take me 4 or 5 months to get a roof contractor out there. So these are all the things that are sort of hitting the strata apartment area and the sector at the same time as phenomenal growth. So I'm really sorry. I think I've put forward a lot of issues. And so I'm going to move to Greg purely later on after this so he can provide the solutions. Look, I'm going to put my REIWA hat on now, and I'm going to be really quick because I think Greg's the person we want to talk to. At REIWA, we obviously got to consult with all our members, and our members are not just sales reps or property managers. We have commercial, we have buyers agents, and we have a lot of people that manage in strata, whether it be commercial or residential. So the key submission items for REIWA, so everyone is aware, is that we actually do believe in strata managers being brought into the real estate licensing regime. We don't know what that will look like. I do believe that if we've got 30% of the complaints being about strata managers, we do need to be better. We are in our infancy. I do say to people that, look, we got an Act in 2024 and we're working through it. You know, it was nice to be recognised, but I'm going to put my real estate hat on now and say, well, from 1987, I've had an act, a code of conduct, and regulations. My disclosure statement as a real estate agent is to tell you the amount I'm getting to everyone before I get it. So I'll give you an example. With insurance, I would need to then absolutely specify the amount that I am being paid before the policy was being actually paid or agreed to. And I have to communicate that to all lot owners. It's just not a feasible practice for us. So when I look at it from the professionally accountability and consumer protection phase, I also look at it from a monetary phase. As a property manager or a sales rep, we don't hold the sale money when it comes through. That's the settlement agent's job. We may hold 4 weeks of rent and give it to an owner at the end of the month. And if we don't give it to the owner, I promise you, we get a phone call by 5 o'clock that afternoon that they haven't got their rent money. Whereas strata money, we're talking millions, and I must admit millions is probably billions, and no one really knows how much money should be in there. I think some audit and some protection in that way is what people are looking for. So in relation to REIWA's submission, obviously the main item is they believe that, strata managers should come under the actual framework of real estate licensing. It would hopefully then add to the professionalism, the accountability, and like I said, the consumer protection. At the moment, SAT is supposed to be the one-stop shop, but the chances of an owner having an issue against a strata manager or a scheme and taking it to SAT, it's really quite minimal. I mean, that's a lot of effort and a lot of money, as opposed to being able to lodge a complaint via demurs. Or some form of regulatory body, a strata commission or something like that. We believe it's absolutely necessary because of the growth in this sector and the fact that we have so many more people that will be living in strata, that it's probably the perfect time to tidy up the strata management issue. So key points in our submission are licensing of strata managers. It's absolutely fantastic we've been recognised. It's absolutely amazing that we now have to have some education standards. But I'll give you an example. If my team don't get their education standards in roughly 2 years from now, we don't have a date yet, there is really no one that's going to check that. There is, unless the strata scheme wants to, end our contract because one of our staff doesn't have that, it's really almost let's get it, but let's also make sure that we're making sure that people are keeping it. We do think that it will enhance professional standards. The next one that we're trying to bring into line is the 10-year maintenance plan. So the way we're sort of looking at it is that 10-year maintenance plans were brought in for schemes above 10 lots or $5 million common property. A majority of schemes in WA actually are less than 10 lots. And what we are feeling is that with those smaller schemes, when something like their roof or their walls go, which a lot of them are because they're built in those 1980s and 1990s, the 6, 7, 8 lot scheme just don't have the money. They've always put away maybe $1,000 or $2,000 a year, and they're the ones that we are taking to court to get an owner to pay a special levy. I'm not saying that the larger schemes are able to pay more, but when you have a $40,000, $60,000, $80,000 roof leak issue and you're splitting it between 20, 30, 40 lots, it's much more manageable. Whereas a lot of our schemes prior to 1996, their roof and their walls are common. So they don't have a 10-year plan, and we have ceilings fall in and they just don't have the money. So we are looking to say that we do believe that 10-year maintenance plans should be extended out to schemes where the building and walls are common property. It allows people to budget for roofs and walls over the next 5-10-year period without these special levies, and it allows for more proactive management, and we're hoping less going to court for these special levies and levy increases. We do believe from a sales perspective, because obviously REIWA does handle a large majority of strata sales in WA, that we also need to simplify the disclosure statement. We know that the disclosure statement has had a massive workover, but a disclosure statement these days is now probably over 100 pages. So we're talking a 10-year plan, a notice of meeting, an annual general meeting. And whilst that information is absolutely fantastic, we are feeling that buyers are signing that without reading it. And I know there's not much we can do about that, but it's almost like the sheer volume of information has almost made it unread. So we do believe that more consumer education is needed, even from REIWA's part, to letting buyers know the importance of reading all those documents and understanding them. We even believe that we need to educate our sales reps and property managers. And if we brought strata managers in, we could do the education process together so that buyers are really, really clear as to what they're buying into. Because I'll give you an example. The sales rep will get all those documents, but they won't necessarily understand them. And a buyer's ability, or even a sales rep's ability, to call a strata manager and have a discussion. We had a lovely session of sales rep v strata manager at REIWA last year, and the two don't talk. So we do feel like the buyer is missing out on the education. And we do think that we need a better dispute resolution process that doesn't require someone taking an application to SAT. And the biggest one, and I don't know, Greg, how this would work, but strata community safety. We have mental health, we have affordability issues, and we have people living in close proximity. Strata managers are bearing the brunt of anger. Again, can be warranted, can be not. Even creditors are being borne the brunt of anger when working on schemes. Neighbours have to live with each other. So debt collection and all these sort of things can become quite nasty. So we're trying to see, very similar to how WHS has a code of conduct as to how we work together. Most professions have a code of conduct, that we almost need a bit of a code of conduct, especially when people are living together. So that just summarised REIWA's submission. I am going to leave it from here. Thank you.
Good morning, everyone. Yes, my name is Greg McGuire, and as this slide says, I'm the Principal Policy Advisor at Landgate, and I'm here to talk to you today about the current 5-year review of the Strata Titles Act that we're undertaking on behalf of the Minister of Lands. So as you'll all be aware, the Strata Titles Act was comprehensively updated through a series of reforms that took effect in 2020. Jamie has said that it's a 1985 Act, but there's actually parts of it that go back to 1966, which is explains a few things in some of the wording. But as part of these reforms that took effect in 2020, there was the introduction of this requirement for a 5-year review, which is a great opportunity for us to have a look at the Act and see how it's performed since the amendments were made. So this review falls due on 1 May. However, we've, at the request of the Minister, Landgate started a bit early, so quite a bit of the work has been undertaken already. So the review is a statutory requirement. However, the Act itself doesn't give us a lot of direction on what we should look at. So Landgate developed a scope to guide the review, and the scope includes 3 key themes, which are improving cost controls in strata title schemes, enhancing strata living, and strata manager practices and standards. And these were just to help guide the review and frame the review as it goes forward. So in the improving cost controls in strata schemes theme, we're aiming to explore issues such as strata subdivision and development costs, financial hardship protections for residents and lot owners, decision-making processes around scheme infrastructure, the budgetary and cost impact of the 10-year maintenance plan, and if the seller disclosure provisions are giving buyers a better understanding of strata costs and what they're buying into. In the enhancing strata living theme, we were looking at issues such as the effectiveness of the scheme governance provisions and how fit for purpose the bylaws are in the Act, looking at proxy voting, also looking at alterations to lots and common property, and plus the dispute resolution aspect. So having a look at whether State Admin Tribunal as a one-stop shop for strata disputes has had an impact in this area. And we're also having a look at the need for a broader strata advice service under this theme. Under the Strata Manager Practice and Standards themes, we're exploring issues such as how the Strata Titles Act can nurture a more skilled and professional industry, looking at standards and compliance requirements for strata managers, looking at trust accounts, management of trust accounts, and also whether a licensing or registration scheme for strata managers was necessary or desirable. The themes are informed by the feedback and complaints and queries that Landgate receives on strata issues, also the issues and correspondence that the Minister for Lands office receives on these kinds of matters, and also feedback from the industry, including industry stakeholders such as REIWA. And while we set out these themes to guide the feedback, any issues, any feedback was welcome, whether it fell into a theme or not. And as you can imagine, with public feedback, not everyone stuck to the format, so we got stuff that fell outside of these themes as well. Before I go on, I've just included some key milestones for the review here as well. So phase 1 was an issues-focused consultation piece where we were trying to identify key issues that people were encountering with the Act and strata living in general, trying to really identify the things that we didn't know, so to speak. And this phase closed on 31st of October, and that consultation piece is now wrapped up. The information collected from this first phase of consultation is informing phase 2. So I'll analyse that feedback and pull it together into the second phase of consultation. So that second phase will be held late in Q2 this year, and we'll seek feedback on some proposed legislative and regulatory solutions to the issues identified in phase 1. And then the feedback received through phase 2 will be fed into the final report, which will be provided to the Minister and tabled in Parliament. We're saying from mid-2025, but that really is going to mean late 2025. So I've included in this slide how Landgate drove some of the consultation on the review. So the Landgate website hosted a consultation page, which included the scope, the review, the discussion paper, and a web form through which people could provide feedback. In addition, consultancy firm Acel Allen also ran targeted interviews with key industry and government stakeholders, and REIWA was one of these stakeholders, but a further 25 stakeholders from industry and government, such as SCA, WA, Property Council, the various utility service providers, the Insurance Council, State Admin Tribunal and Law Society, among others, were also interviewed to get their feedback. The consultation period was communicated to the public through a month-long advertising campaign, and that was across industry, community-based and social media channels. And through this advertising, we asked for feedback, and feedback we got. So when the phase 1 consultation closed, we had over 12,000 visits to the consultation webpage, over 1,600 comments from 578 participants. And this public consultation was supported with 19 interviews with 26 industry and government stakeholders. The percentage of comments received online through the consultation page were pretty evenly split, and we like to think that means we've hit the nail on the head with the themes and that they were about right. So as you can see, 26% of the responses were cost related, 27% were living issues, and 23% related to strata managers. The remaining 24 dealt with other issues, but on analysing these, a lot of them could actually shuffle up into the themes. Just over 87% of the online respondents were strata owners, and that's probably not surprising given that this was the main way that people were providing feedback, or the general public were providing feedback on the review. So the remaining stakeholders, about 3.5% were tenants, 2.5% were strata managers, about 1% were potential strata buyers, which was a little bit interesting for us. A further 2.6% were other industry professionals. We also received a bit of feedback from property developers as well, and the remaining 2% identified as none of the above. I haven't counted the industry and government submissions in here, as they don't make a particularly significant difference to the spread of responses. We spoke to 4 utility service providers, so if I'd added an additional 4 people or 4 organisations in there, it doesn't really move the needle. However, that industry and government feedback is included in the following slides, which will set out some of the key insights from the phase 1 consultation. And before I go on, there is a big caveat on these. These insights include the key and most prominent findings from the phase 1 consultation. Because an issue isn't here, it doesn't mean we didn't receive feedback on it and that feedback wasn't considered or is not being considered. We're looking at all of the feedback that we've got. And likewise, just because something is listed here, it might not be reflected in the final report either. There is a lot of issues that have been raised that might have a common solution. So the final report or the discussion paper might focus more on the solution rather than the issue. But moving along, under the improving cost control theme, we saw the following issues. So subdivision development and termination costs were key, and this is particularly for developers and government stakeholders. There was consistent feedback that some of the processes around creating and terminating schemes have become more convoluted and more time consuming under the recent changes and the amendments to the Act. There was also a sense that there was some duplication in the processes now, which is not ideal. Apartment affordability was another issue raised here. There were concerns that rising costs associated with living in strata title schemes would make apartment living less affordable and less attractive. Utility services connections also came up quite a bit in this space. The main issue here seemed to be that developers and lot owners weren't necessarily aware of who was responsible for the installation of these services. And linked to this was the cost involved in providing utility services to schemes that were in infill or very large developments. If you've got a lot that's sort of in the back right hand corner of a large scheme, how do you get your utilities to it? Community and buyer awareness of costs involved in buying into schemes came up quite a bit here as well. And this was twofold in that there's a need for people to be aware that there are ongoing costs in buying into a strata scheme, as well as what those costs are, how they're calculated and how they can best be managed. The collection of overdue levies and contributions is another emerging trend here. The feedback is showing this is a growing issue for strata companies, as Jamie set out earlier. And the costs associated with managing these debts and running schemes where contributions are outstanding were highlighted as problems here. But also in this area, the importance of having some sort of consumer protection around people experiencing financial hardship also came up, and there was some evidence received that there has been a bit of a spike in bankruptcies caused by people that are unable to afford their strata fees and their levies. Strata levies and contributions is another area in the cost controls theme. So lot owners are obviously worried about increasing costs, and this is across the board. It's not really confined to one area. So it includes the cost of levies and contributions, cost of maintenance and repairs, cost of strata management fees, cost of legal advice. Sort of everything is too expensive, is the feedback we're getting. And linked to this is value for money and transparency of contributions. As these costs rise, lot owners want to be sure that they're only undertaking and therefore getting charged for the things that are necessary for the proper upkeep and running of their schemes. There was some feeling that they were getting charged by tradies and service providers for things that probably weren't necessary at a particular point in time. And to that note too, lot owners also want transparency around how contributions are calculated and what they're spent on. We're also seeing feedback on the impact of the 10-year plan. There's some really interesting feedback in this space, a lot of positive and negative feedback as well. People really thought it was a hassle, highlighted the cost of pulling one together, getting the right people to do it, and you'd read through the feedback and think, gee, people hate these things. Then at the end, everyone said, but it's a really great thing and more schemes should be doing it. So there was a push or some feedback that suggested there would be benefit in rolling it out to smaller schemes, and also perhaps providing some more guidance to help schemes manage the plan better, prepare it in a more meaningful way and fund it as well. What else we got? So auditing of strata company accounts was another issue that was raised within this theme, and there was a call to increase legislative requirements around the management and auditing of strata company accounts. Also, the ongoing impact of building defects is the final issue under this area, and specifically, this is where a developer has avoided addressing a building defect during the warranty period, and then the strata company is left to deal with it and pay for rectification. Scheme insurance is the final trend under this theme, and this is probably not a surprise. Access to suitable insurance was a common issue, and that is schemes being able to get access to insurance that meets their needs and the requirements of the Act. And the increasing cost of insurance premiums was the other key concern raised here. Again, I think these have been on the radar for a little while, but it's good to get some public feedback and reiteration of the issue for us to have a look at. Moving on to the Enhancing Strata Living Scheme, we're seeing the following trends arise through the feedback here. So issues in the community living space, there was feedback that there needs to be more buyer, developer and real estate agent education on strata title schemes. The feedback suggested that if people were better educated around what strata title schemes were and how they operate, that some of the issues that we're seeing might not eventuate. We've received the feedback on increasing levels of bullying and intimidation in schemes, and this is across the board again, which is disappointing to see. And it's not limited to lot occupiers, strata council members, and strata managers, but it also includes bullying of tradies, and other service providers that come onto schemes, as Jamie outlined earlier. The use of proxies was another issue that came up under this area, and we've seen a lot of feedback from lot owners who feel like they're being frozen out of scheme decision making because a single person holds proxies for the majority of lots in a scheme. And through this feedback, there are calls to put further limits on the use of proxies for scheme decision making, and a call for more legislative controls on how proxies operate. Maintenance of utilities is another emerging theme here. And there is some confusion and uncertainty around who's responsible for the maintenance of scheme utilities. And certainly feedback was received that points towards the need for more clarity around the responsibility for maintenance of utilities, especially when they're servicing an individual lot, but they cross other lots and common property. Dispute resolution and strata advice for the final recurring issues under this community living issues area. Certainly the need for better strata advice with a view to heading off issues essentially before they can go to the state admin tribunal. Interestingly, the feedback indicated that the state admin tribunal was probably pretty good at actually resolving disputes. However, the feedback also indicated that people still considered there was barriers to accessing SAT. So the application cost, the fact that it's still a type of court setting, and the legal advice and representation, whilst it's not a requirement, the feeling was still that if you wanted a good chance of success, you should get legal advice and representation before getting to SAT. So the feedback seemed to indicate that if you could get to SAT, if you got to SAT, they'd probably make a pretty good decision, but there was still barriers to entry to actually accessing SAT. And in this regard, the feedback also indicated an appetite for a cost-effective dispute resolution option that sat between scheme-level dispute resolution and the actual state admin tribunal. The wording of the Act came up quite a bit as well. To reiterate, yeah, it's currently a 2020 version of a 1985 version of a 1966 Act. So the feeling was that there's parts of it that certainly weren't very, very modern, and part of this was that perhaps there should be some objectives in the Act that might help strata companies, developers, and government better apply and understand the Act. The wording of the current Schedule 1 and 2 bylaws was also a recurring issue that came up as part of the feedback, and this is one of my personal favourite bugbears with the legislation as it currently is. The feeling is that these bylaws were out of date and no longer meet contemporary needs for people living in schemes. And along with this, there was a feeling that they were at times confusing. They cover areas and issues that are probably no longer important to people living in strata schemes, and they impact on the application of other laws. And there's also an issue here that there are a broad set of bylaws where if you're living in a built strata that is a building with a car park, no gardens, no lawns or anything like that, you may still end up with bylaws that say, you've got to look after your lawns and gardens when you have none. In this area too, there was also feedback that the bylaws were too hard to change, and this is especially in the area of short-term rental accommodation. So the other emerging themes in the enhancing strata living area were the operation of councils, strata councils, the knowledge gaps, or just a general poor knowledge of strata laws by people sitting on the strata council was raised quite consistently. Conflicts of interest and lack of transparency of decision making also came up quite regularly here. There's a feeling that sometimes strata council members have relationships with developers, strata managers, property maintenance companies, or other outside parties that service or have an interest in the scheme, and therefore don't always act in the best interests of all strata owners in the scheme. Feedback also indicated that sometimes the council holds too much power over the running of the scheme, and it was difficult for lot owners to find out the reasoning for some strata council decisions, and that in some schemes it was difficult to get onto the council. That was quite a well guarded position. The lack of action and communication by strata councils on issues within schemes was another emerging trend here. And on this note, the feedback seems to fall into two extremes, in that the councils all controlling, or they do nothing. But regardless of the end of the spectrum they fall on, the feedback was that the strata councils aren't communicating with their schemes. In a similar vein too, we got a lot of feedback on issues with the enforcement of bylaws, and again, it fell into two extremes. Either there was no enforcement, or perhaps some overzealousness enforcement of scheme bylaws. Scheme development and renovations were another emerging issue in this theme. Stakeholders reported lower than expected building standards and defects in buildings that were impacting their standard of living. It was also felt that there were not enough consumer protections in this area for lot owners and strata companies. Clarity around lot alterations was another key issue here. Feedback indicated that the Act isn't clear on the processes that lot owners and strata companies need to go through when someone wants to undertake renovations on their lot. And this was a particular issue when renovation might impact common property, or where conduits need to run through other lots or common property as well. And the final issue here was smoking in schemes. And there was a number of health and smoking not-for-profits that had a grassroots campaign around that, which is probably why it was so prevalent in some of the feedback. But smoke drift from lots and common property, as well as a lack of smoke-specific bylaws, were the key issues that came through here. Moving on to the final theme, so strata manager practice and standards has shown us certainly some useful insights. The quality of service provided by strata managers is a first emerging trend here, and despite what you're thinking, it isn't all bad. There was a lot of feedback from people that were very happy with their strata managers. However, when a scheme got a really good strata manager, that they were really happy with, they were very reluctant to share that information. And it seems to be that they're reluctant to share that information because the feedback certainly showed the feeling that lot owners thought their strata managers were overextended and were certainly experiencing high staff turnover. And leading on from that, perhaps this links with the issue that strata companies felt that strata managers were slow to respond to issues. Obviously, if you're having high turnover or don't have enough people to do the work, that impacts your ability to be able to actually respond to issues in a timely way. The cost of management fees charged by strata managers also came up quite often here. And again, this is across the board. So the overall fees charged, as well as the fees for specific services, the feedback was that it was all too high. Again, perhaps not surprising, obviously, in a cost of living environment that we're in at the moment. Conflicts of interest was another key area that came up under this theme, and again, this is probably not surprising given the recent media and press coverage of these kinds of issues on the East Coast and other places. Lack of transparency of commissions paid to strata managers by service providers was an issue we saw a lot of feedback on. The feedback's also flagging instances of relationships between strata managers, developers, and strata councils, which don't necessarily benefit the whole scheme. And there's also feedback on the effectiveness of the disclosure regime in the Act and whether this should be expanded to third parties. And that is to say, whether disclosure requirements should be attached to scheme service providers who aren't necessarily strata managers. Industry regulation was another reoccurring issue within the feedback, and again, this didn't really come as a surprise. The lack of industry-wide standards for strata managers was raised as an issue by a range of stakeholders. The feedback is also showing a push for licensing or registration of strata managers, and there's three models that were raised through the feedback. There's a full licensing model, which will be similar to what applies to real estate agent. There are real estate agents, not just one. A registration model where if you meet the requirements of the Act, you can register to be a strata manager, and then there'd be government oversight of the people on the register. And the third model was developing a regulatory body, which is delegated the oversight role of the industry there. And along with the licensing and registration comes a desire for improvements to the accountability of strata managers where they breach strata law. And the feedback here also suggested, showed a desire for a legislated requirement for audits of trust accounts held by strata managers. Also, interestingly, there was quite a bit of support for continuing the strata manager annual return and making that an ongoing and regular requirement for strata managers. And finally, in this space, strata manager educational experience requirements was an emerging trend, and the feedback indicated a desire for a more educated and experienced strata management industry. And along with this was a desire to improve the working knowledge that strata managers have of the Strata Titles Act. So I'll just close out my bit by providing an overview of the next steps in the review process. So that now that phase one has closed, we're consolidating, we have consolidated the public and industry feedback, identified the issues that have come out from that feedback and analysed them. We're currently looking at potential legislative and regulatory solutions to these issues that have been raised. And that will feed into the phase two discussion paper. And as I said earlier, that will be put out second quarter of this year. The feedback from that phase two will then be analysed, and that will form part of the, it'll make up the main part, I would expect, of the final report that goes to Parliament. And then that will be tabled by the Minister in the last half of 2025. In a nutshell, that's the phase one consultation outcomes.
Excellent. Thank you so much, Greg, for the overview. And thank you, Jamie. And we had a lot of comments come through after your session as well to say thank you for the overview that you'd given. Obviously, there were lots of similarities between the things you mentioned, Jamie, and also the things that came up with Greg. And we've also seen some of those themes represented in chat as well while you've been speaking. We're almost at the end of time, so maybe we've got time for just one quick question, if that's okay with both of you, before we finish the session. So one of the questions that were sent in were, how can WA strata scheme governance be improved to ensure fair and transparent decision making, prevent undue influence by single individuals or entities, and maintain the Council of Owners accountability to all owners? And then just from chat, another question that was similar and can pop in there as well. Should the developer builder be limited to the number of proxies like in New South Wales?
Improving the strata scheme governance on that council level is a little bit of a tricky one, because there's already statutory obligations in the STA around strata council members and conflicts of interests, and always acting in the best interests of the scheme. So what came through the feedback was the need for better education of strata companies and strata councils, and that certainly came through quite loud and clear. But it's difficult to legislate for this stuff. It's probably not feasible to say, well, if you buy a lot in a strata title scheme, you've got to go off to TAFE and do a certificate 3 or something to understand what you've bought into, what your role is, I should say. Perhaps sort of providing some documentation that's akin to that buyer disclosure statement for when people come onto a council or something could be an option in that space. But some of the other suggestions that came through in the feedback were clear reporting requirements for councils to their strata companies and strata companies more generally too, and that was especially in the area of financial reporting. And the examples that came through, people would like a better breakdown of budgets and expenses so that lot owners understand where their money's gone. And as an example, we'd seen some like invoices for quarterly fees where it was essentially just a number, and no breakdown of how that number was come to. And of course, the better schemes or more involved schemes, I should say, do have the ability where you can actually drill down on that and see how it's been calculated and brought together. The feedback also indicated a desire for more regulation around proxies, so that one person or one entity doesn't have undue influence over the entire scheme. And that's certainly been on our radar for a little bit of time as well. And there's some options here. There's obviously some restrictions on what developers can do under the current act in terms of voting on scheme defects. Do we need to make those stronger? Do we need to bring them to the fore? Would be something that we're looking at, and also perhaps broadening that, making a more of a blanket prohibition on developers holding proxies. But again, it's a tricky one, because there might be some areas where it makes sense for the developer to hold a proxy. Obviously, you don't want a scheme to get halfway through developed and then have lot owners vote for it to be shut down. What else came up? Oh, also we got feedback that it would probably be desirable to make it easier for strata companies to remove strata council members. There is provision for that in some of the bylaws already, but the feeling was that there's probably some gaps in the legislation there that might leave a strata council member with nefarious intent in place for longer than what's desired, while you pull together meetings and resolutions to get them removed. And also this ties in with dispute resolution as well, in that if we can make dispute resolution better, however that might look, then hopefully better accountability would flow from that as well.
And we did have lots of conversations happening around the dispute resolution process as it sits at the moment, Greg. So what sort of ideas are you discussing? Can you share any of that with us, or have you thought that far ahead yet? Or
we're certainly thinking that far ahead. I mean, the feedback shows a really strong desire for something like a strata commissioner role. that would be a semi-judicial role, I guess, akin to the building commissioner or something like that. So there's been strong calls for that. So we're having a look at that as part of phase 2. And there's certainly limited options in that space. We got really good feedback from State Admin Tribunal through the interviews they had with ASIL Allen, and they would certainly like to do more, but they're just a very, very busy jurisdiction at the moment, and it makes it difficult not only for them to, of course, hear cases, but also what they publish, the materials they produce, and the information that they put out. It also hampers their ability to do that. We didn't realise that a whole bunch of strata disputes that go to SAT actually get resolved through SAT mediation before they go to a hearing, which was, I guess, a little bit of a surprise for us. We knew that service existed, but we didn't know that it was quite as effective as SAT has now told us. So yeah, perhaps a more state government offered mediation service might be another option there as well.
I just wanted to say thank you to everyone, and the chat looked amazing. I love all the opinions that we do have, and I must say, look, I think there's a lot of common themes.
Keep an eye on the Landgate website for updates on the review, and when we do move to phase 2 consultation, that's where it will be available.
And maybe at that point we can revisit this session and go through what has actually come out of the phase 2. It's
important to remember that this is just a review of
Yes.
the Act. It's not necessarily, there's a whole process that needs to be gone through once this is done to actually change the Act. And as with all things legislation, it's not going to be a quick and easy thing to do. And of course, we just had an election on the weekend as well, so we're waiting with bated breath to see who our minister will be going forward. And yeah, it will really depend on the appetite of the new government to have a look at this as to how quickly it will move from here. Well, not even from here, from when we deliver the final report.
Okay. All right. Wonderful. Okay. Well, thank you so much. Keep in touch, and we might see you on our screens later in the year, giving us a further update.
Thanks, folks.
Excellent. Thanks so much. Thanks, Jamie. If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.